I am also aware of the use of information technology by Court Act 2020 in Bangladesh, which provides for virtual court proceedings, including trials, appeals, evidence taking, and judgment delivery. This represents a significant advancement in ensuring access to justice. I wish to extend my congratulations to the judiciary of Bangladesh. Honorable Chief Justice of Bangladesh, Justice Obaidul Hassan, Honorable former Chief Justices, Honorable Justices of the Supreme Court of Bangladesh, Honorable Justice of the High Court of Bhutan, Lobjang Rinjing Yark, Attorney General of Bangladesh, and Senior Advocate, Excellency Ambassador of Nepal to Bangladesh, other bar members, Registrar Generals, and other staffs, ladies and gentlemen. At the outset, let me congratulate Chief Justice Obaidul Hassan on hosting this conference. I extend my sincere thanks to him for inviting me and for the warm hospitality extended to me and my delegation. I am pleased to present before this esteemed gathering a practitioner's perspective on institutional fairness and shared experiences from Nepal. To me, fairness is synonymous with justice. When considering institutional fairness, I am drawn to two core principles: the autonomy of institutions to function independently, and the safeguarding of human rights, ensuring equitable access to justice for all. These ideas encompass the notion of the rule of law, judicial independence, accountability, and democracy. While discussing independently institutional functionality, factors such as institutional independence, efficiency, and fairness come to the fore. Institutional fairness is the bedrock upon which the realization of equality and justice for all rests. Independence of judiciary, both in structure and function, is a prerequisite for institutional fairness. This independence is typically guaranteed by the Constitution, providing a framework for the impartial, effective functioning of the judiciary. The basic principle on the independence of judiciary, 1985, and the Beijing Settlement of Principle of the Independence of Judiciary in 1995. Both emphasize judicial independence must be guaranteed by the state. The Constitution of Nepal, founded in the principle of fairness and equality, designates the judiciary as the ultimate interpreter and custodian of the Constitution. It enshrines judicial independence as a core constitutional value. This independence is the both institutional and individual, that is, independence of judges in their functions. According to the Bangalore principle of judicial conduct, judicial independence is a prerequisite for fair trial and the rule of law. The Constitution of Nepal guarantees the right to justice as a fundamental right. The Code of Conduct for Judges in Nepal, which broadly aligns with the Bangalore principles, emphasize equality and fairness as a key component of judicial functions. Like other democratic constitutions, our Constitution embodies the principle of separation of powers and checks and balance. While each branches of government operates within its designated spheres, the judiciary is empowered to review the action of the other two branches in light of constitutional provisions. The judiciary, particularly the Supreme Court, can exercise judicial review to declare laws and execute action unconstitutional. While discussing fairness in the judiciary, the question often arises, fairness to whom? The judiciary must be fair to all parties involved in a case, the accused, the victim, and society at large. This requires treating all parties, including victims, with equality and respect. The The right of human dignity is a fundamental right guaranteed by Constitution, and the Supreme Court has frequently emphasized these rights as the most fundamental among constitutional rights. The Code of Conduct of Judges in Nepal recognizes equitable as a core value and essential element of the judicial process. Given that legal aid is essential to ensure fairness, Nepal places significant importance on the legal aid. The Legal Aid Act 1997 provides legal assistance to indigent individuals who are unable to protect their legal rights due to financial and social constraints. Legal aid is provided through court-appointed lawyers, civil society organizations, and pro bono services from the bar. Legal representation is mandatory in criminal cases, and in the developing countries like ours, legal aid is crucial for indigent parties in a civil case as well. Ensuring legal representation, the both criminal and civil matter in imperative to uphold human dignity and humanizing the judicial process. Honorable Justices and distinguished participants, here I wish to discuss three crucial components of judicial reform in Nepal aimed at enhancing fairness, efficiency, and public trust. First, legal reform has been significant. In 2017, Nepal replaced the old Mulki Ain, which had been in place for over 160 years, with comprehensive and new code governing criminal and civil matters. Notably, Nepal perhaps became the first country in South Asia to implement the Sentencing Act and sentencing guidelines. These laws were enacted through the collaboration efforts of the judiciary and the bar. Second, Nepal has embarked on management reform within the judiciary by introducing 5-year strategic plans. We are currently executing the 4th 5-year plan and are in the process of promulgating the 5th plan, which will be unveiled in July this year. This plan focuses on various aspects of case management to ensure timely case resolution. A major component of this reform is the ICT-based case management, differentiated case management, DCM system, which provides a tailored pathway for each type of case for its registration date to final disposal. This system ensures the predictability and transparency of the judicial process. Additionally, Nepal is making stride towards a technology-based judicial system. Recently, we have initiated automated system to schedule cases for hearing, virtual hearings, and online registrations. We have established integrated case management system will avail details regarding process of any case right from the stage of its registration at the trial court. Full text of judgment of the Supreme Court have also been made available through our website by multiple search options. These advancements have significantly improved accessibility and transparency within the justice system. Given Nepal's challenging geographical and unreliable roads, physically reaching courts has been difficult for many. The introduction on online hearing and other digital systems has made justice system more accessibility to the public. I am also aware of the use of information technology by Court Act 2020 in Bangladesh, which provides for virtual court proceedings, including trials, appeals, evidence taking, and judgment delivery. This represents a significant advancement in ensuring access to justice. I wish to extend my congratulations to the judiciary of Bangladesh and Honorable Chief Justice Obaidul Hassan for his endeavor. Now, Nepal is enhancing the fairness, efficiency, and trustworthiness of the judiciary system through legal reform, management reform, and integration of technology. To improve transparency in case assignment, this We introduced a raffle system for allocation cases judges 2 years ago. This system has been effectively in all courts, even in Supreme Court also. In our justice system, our courts are involved not only in delivering judgment, but also in their execution. Judgment execution director within the Supreme Court oversees the execution judgment by the district court. Another crucial component of judicial reform in the capacity building of judges, which has been undertaken by the National Judiciary Academy, NJ, since 2004. The NJ also serves as a center for knowledge enhancement and research for judges. It offers training on subjects such as judicial ethics, code of conduct, and judicial management with aim of improving institutional fairness, efficiency within the judiciary. Honorable Justices and distinguished participants, then let me allow to address the second component, the institutional fairness, human rights, and access to justice for all, which I mentioned earlier. Access to justice involves both seeking justice through relevant institutions and ensuring that these institutions have the capacity to provide it efficiently. Nepal is committed to ensure access to justice through its legal and institutional mechanism, aspiring to achieve social transformation by establishing an egalitarian society based on the principle of participation and inclusion. The Constitution of Nepal guarantees a broad area of fundamental rights, including the rights of social security and social justice to safeguard human rights for all. It provides special protection for marginalized and minority groups. The role of the court in ensuring human rights and access to justice has been pivotal. The Supreme Court Nepal has delivered decisions safeguarding constitutionally guaranteed rights in diverse areas, including food security, health rights, and social justice. Recently, in the case of Prakash Nepali versus Secretary of the Federal Parliament, the court emphasized the need for the creation, reformation, and strengthening of a legal, institutional, and policy-based mechanism to promote social justice in the context of the Dalit community. It issued comprehensive directives for the implementation of the right of Dalit and individuals. The decision builds upon the previous judgment in Binay Kumar Panjiar versus Nepal government, where the court ordered a detailed study of various laws, plans, and policies to establish institutional mechanism aimed at equitable empowering socially and culturally marginalized citizens through positive discrimination measures. With human rights, environmental rights increasingly recognized as interconnected, protecting these rights is essential for ensuring effective justice. The Nepal judiciary has been addressing climate and environmental justice for a human rights perspective also. Several Supreme Court decisions have highlighted the harms posed to human life by environmental degradation, outlining the state's obligation, and emphasizing the importance of sustainable development. A recent judgment by the Constitutional Bench in Shailendra Ambedkar versus Government of Nepal declared any government action causing widespread harm to the environment, biodiversity, and people depends on these environments as ecocide. Similarly, in Deepak Mishra versus Office of the Prime Minister, the court directed relevant institutions, including ministries, to take action to safeguard Mount Everest and protect the people living in the mountains from the effect of climate change and extreme human interference. These cases, among many others, underscore the Nepalese judiciary role is upholding institutional accountability for environment and climate justice. Honorable Justices and distinguished guests, South Asia countries in South Asia facing similar challenges, which requires initiative dialogues. Dialogues among judges should be integral to the process. In the past, the SARC law served as a forum for bringing together judges and lawyers. We also organized environmental justice round table to engage judges and lawyers for South Asia. Last year, Nepal hosted the Forest Conference in Kathmandu, where justices and judges from South Asia discussed forest issues heavily impacted by climate change. Given the global nature of human rights and emerging common challenges, strong cooperation among states is crucial for enhancing the judiciary institutional capacity to ensure justice for all. Platforms like these provides opportunity to learn from the best and most innovative practice of different nations. The Supreme Court of Nepal frequently refers to good practices from other countries, particularly in South Asia. Efforts to promote human rights, fairness, and justice in own courts can offer valuable inputs for others. Honorable Justices and distinguished guests, now I would like to conclude by emphasizing that justice extends beyond individual cases or the mere formulation of laws. It fundamentally resides in how institutions and individuals perform their duties with fairness, equity, and a deep respect of human rights. As Amar Singh has pointed out, it is a core justice is about fairness, which includes freedom and capabilities, and involves addressing the barriers to these ideals. Justice should not be viewed as a final destination, but as a continual process rooted in institutional fairness. The fairness underpins our legal and judicial system, ensuring the operation in principle equality, impartiality, and transparency. At last, I am going back home with keeping the memory and faith to Father of Nation Bangladesh, Sheikh Mujibur Rahman. Once again, I thank the Honorable Chief Justice of Bangladesh for organizing this conference. I wish successful conclusion of this conference. Thank you all for your kind attention. Thank you.